yourself into. And so I'm going to have a fairly lengthy conversation at the beginning of this, but really after I get through this, the focus really turns to what you all want to say. So be patient with me because I do have to go through this material, and it's important because you may have questions about it. I sent you the agreement to mediate and a description of mediation in the mail along with my bio. Did you both get that and have a chance to spend some time with it? Okay, good. So some of this will be redundant. If you've read through the agreement to mediate, some of it will sound very familiar, but it's important that we go through it. The bathrooms are down the hall, and the women's restroom is first once you turn this right-hand corner, and the men's is clear on the other end. If you need to use a phone, we can make arrangements for that. We've got beverages and some snacks set up for you. Feel free to take advantage of those anytime that you want. You know, there's nothing that says you have to stay planted in these chairs. If we need to take a break, or you need to walk around, or you need to call somebody for information or just to check in. I don't know what conflicts you might have today or things that you're worried about at the office that we can make time for you to check in and make sure everything's going smoothly back there. I know these chairs are a little hard. If they get too uncomfortable, let me know and we'll try and figure out something else. If the sun's in your eyes, be sure to tell me that. If it's too warm in here, let me know about that. Obviously, my job is to make you as comfortable in this process as possible, so please let me know if anything's not working for you. I am a professor at the Appalachian School of Law. I teach negotiation, mediation, arbitration, and dispute resolution system design. I have a Master's of Law in Dispute Resolution from the University of Missouri-Columbia, and I practiced law for 20 years as a commercial litigator. I shifted from litigation to mediation because I feel so strongly about this process and the promise of it to solve problems for people. Mediation is a voluntary process in which basically I help you all talk to each other in a way that's meaningful to both of you. And once we understand the kind of problems that you all are facing at this point, then we can shift into some of these later stages and start to develop options for you to solve those problems. And we'll talk about the stages of mediation in just a moment. But the biggest characteristics about mediation is that it's voluntary and you're the decision makers. I can facilitate with the process, but ultimately the decision making is up to you. I mentioned that I was trained as a lawyer and I'm a law professor, but I want to make sure you understand that I am not going to be acting like a lawyer today. I'm not going to be giving legal advice to either party. If it looks like you may need some legal information, we can arrange for you to get that information. It's important that you feel you can talk to your lawyers at any time in this process. If you want to take a break and call your lawyer, that's fine. We will put together a draft agreement at the end, and I assume that we'll get to an agreement because most parties do. And you'll have the right to take that back to a lawyer and have a lawyer review it before you make it final and binding on you. Any agreement that we reach today that you all sign will be final and binding. It'll be like any other enforceable contract. And so you have to be careful about that. You may want to talk to a lawyer, and it can affect your substantive legal rights, so you need to know that. When we're done with this process, you need to know that I can't represent either of you as a lawyer. There's a couple of reasons for that, but we don't want you to misinterpret any future relationship that I have with either of you as some sort of conflict of interest that existed now. And that leads me into really my role, which is to remain impartial. And in fact, it's more like I want to support both of you through this process. I don't want to look like I'm helping one side more than the other, because to me it's important that you both feel supported in a way that you can come together in this agreement. Now, if at any time you think that I'm showing bias or favoritism for or against one of you, tell me and we can talk about it. Sometimes it's a misinterpretation, sometimes it could be very real, in which case we need to get you another mediator so that you don't feel like this process isn't working for you. I am not trained as a therapist. I'm not going to be giving therapeutic advice. As I mentioned in my agreement to mediate, I have a facilitative style of mediation. And what that means is I'm really not going to be providing an analysis of a legal case or an evaluation. This doesn't strike me as a kind of dispute where that is really what's happening. I guess in theory it could end up in litigation, but right now it's really something that we should be able to work out without thinking about all the legal aspects that might come out of it. Facilitated mediation really just means that I'm here to help facilitate a conversation. Could be a difficult conversation, but we're going to just have a conversation. The benefits of mediation tends to be less costly than some of the other alternatives, tends to be more efficient in terms of really finding options that really help you guys solve the problems that you're facing, and tends to be quicker in the sense that we really get to focus on the problem today and see what can come out of that. Stages. So right now we're in the opening orientation, and like I said, this will be the longest I ever talk. And then we'll take some time, and we'll take as much time as we need to get your perspectives on things. And then once we sort through all that, we'll identify the issues that we need to work on and set an agenda. And then based on those agenda items, we'll start generating options. And after we take a look at those options, then we'll start to evaluate which ones make sense, which don't, and then you'll pick those and they will go into some sort of agreement at the end. And that's really the closing part. And the closing also includes things like, let's say you get an agreement on some things, but maybe not on others. Fine. What do you want to do about those others? Is there another process that you can use? Do you need to get more information? Do we need to schedule a second session? Do you need to talk to your supervisors before you can go forward? Do you want to file a lawsuit? Do you want to file arbitration, depending on what your workplace contracts say about that? So we'll have to figure out what is the next step once we get there, depending on what's happened today. Why don't we just take a quick break here, and I'm going to ask you if you want to get some coffee or something to eat, to go ahead and do that now, or if you need to use the restroom. So, you want to take a break?
I'm not going to.
Okay. All right, so